Welcome to the Accessibility for Ontarians with Disabilities Act Employment Standard Training module. Hereafter, this module will refer to the Act as the AODA. AODA Employment Standard Training is a requirement of the AODA. This employment standard training was created for organizations and employers to train their employees and all other obligated persons about the Accessibility for Ontarians with a Disability Act. The content of this module is not legal advice, but does serve to satisfy the requirement for employers to train and educate their employees as required by the AODA. If there is a discrepancy between this training and the Act, or any amendments to the Act that arise after this training has been completed, the Act will always prevail. In this module, you will be provided with a brief overview of the AODA, as well as the 5 standards that make up the Act. You will learn about the general requirements of the Integrated Accessibility Standard, as well as the specific requirements that derive from the Employment Standard. The standards will be reviewed in light of the requirements that are placed upon both the employer and the employees as imposed by the Act. Currently, 1.85 million people in Ontario have a disability. That's 1 in 7 people. Over the next 20 years, as the population ages, it is estimated that the number will rise to 1 in 5 Ontarians. People with disabilities do not have equal access to services, employment, transportation, information, or to some facilities that we all should be able to enjoy. The AODA was passed with the goal of creating standards to improve accessibility across the province. The AODA became law on June 13, 2005. The purpose of the legislation is ultimately to provide for accessible Ontario to people who have a disability. The legislation focuses on different key areas in succession: developing standards for customer service, information and communication, transportation, employment, and the built environment. As such, the AODA is made up of 5 standards, each addressing a different mandate, but all with the same unified purpose. Deadlines for compliance are staggered, ranging from January 1st, 2012 into 2025. The AODA applies to all levels of government, non-for-profit, and private sector businesses across Ontario who have 1 or more staff. And as the AODA is law, the Act provides for government authority to set monetary penalties to enforce compliance with the standards. The AODA was broken down into 5 stages or standards, as they are appropriately referred to. Each standard addresses a different mandate or focus. The customer service standard was the first stage introduced, and all obligated organizations should have already met the requirements. On June 3, 2011, the Ontario government released the final Integrated Accessibility Standards Regulation. This regulation combined accessibility standards in 3 areas: information and communication, employment, and transportation. The goal of the Information and Communication Standard is to outline how organizations will be required to create, provide, and receive information in a way that is accessible to people with disabilities. When requested by a person with a disability, the organization must provide an accessible form of communication that takes into account the specific needs of the individual. These alternative formats and communication supports must be provided or arranged by the organization at no additional cost to the person and in a timely manner. The employment standard is the focus of this training module and will be addressed throughout. The transportation regulation is limited in its scope, applying to modes of transportation under the jurisdiction of municipal and provincial governments. The standard provides that transportation services must be provided in accessible vehicles, or equivalent services must be made available upon request. The Built Environment Standard focuses on removing barriers in buildings and public spaces such as beaches, recreation trails, parking spaces, and outdoor play areas. Enhancement to accessibility in new or retrofit buildings have already started to be mandated through Ontario's Building Code, which governs new construction and renovations in buildings such as entrances, doorways, and corridors. To date, the Built Environment Standard has taken on numerous versions, and it is still unclear what exactly we should expect in the way of regulation and requirements. The Integrated Accessibility Standards Regulation, or IASR, is made up of 3 distinct standards with their own specific requirements. The IASR also includes a section of general requirements that apply to all the standards in the regulation. The general requirements to be fulfilled by all obligated organizations are the establishment of accessibility policies and necessary accessibility plans, the establishment of accessibility measures as it relates to the procuring or acquiring of goods, services, or facilities, regulations regarding the accessibility and specifications of self-service kiosks, employer-provided training to designated employees for both the 3 standards that make up the IASR and training in human rights awareness as it relates to those persons with a disability. And the IASR also outlines the cases where there would be an exemption from filing accessibility reports. The first general requirement that applies across all standards is the establishment of accessibility policies and plans. Every obligated organization must develop, implement, and maintain policies governing how the organization will achieve accessibility through these requirements. In addition, public sector and large organizations, which is defined as an organization with 50 or more employees for the purpose of the AODA, must establish and maintain a multi-year accessibility plan, which outlines the organization's strategy to prevent and remove barriers and meet its requirements under this regulation. The plan must be posted on the organization's website and must be provided in an accessible format upon request. This plan must be reviewed every 5 years, and necessary updates must be made within that time frame. For large employers, the accessibility plan will be posted along with or in addition to the Statement of Commitment. The AODA Customer Service Standard required all large organizations to develop, maintain, and post a Statement of Commitment which describes its accessibility policies, practices, and procedures, and makes the public aware that the accessible customer service is available to all persons upon request. The document should be posted at a conspicuous location, ideally where the customer would first require customer service, and/or it may be posted on the organization's website. In addition to the requirement for accessibility policies and plans, the standard mandates that obligated organizations must incorporate accessibility criteria when procuring or acquiring goods, services, and facilities. The new expectation is that in the process of purchasing or acquiring new goods, services, or facilities, the requirement to provide accessible services will be taken into account. For example, it may be that time for your company to reconsider your advertising campaign. This regulation would require you to consider the barriers in your print and communication materials that may pose a challenge for persons with disabilities. Examples of barriers in printed materials would be small print, unclear fonts, or shades of colors that may worsen the effects of color blindness. A kiosk is a small, self-standing structure that people can use for a variety of functions, including commerce, information, education, etc. When most people think of a kiosk, they likely refer to a bank machine or an auto checkout at their local grocery store. Kiosks have taken on a much larger use in today's society and can be used for anything from updating or renewing your driver's license to quickly getting across an international border. In realization that the use of self-service kiosks is heightened in today's world, the IASR places accessibility requirements on both private and public sector organizations when designing or purchasing kiosks. Public sector organizations are now required to incorporate accessibility features when designing, purchasing, or acquiring self-service kiosks. All other businesses in Ontario must consider accessibility when designing, purchasing, or acquiring self-service kiosks. The IASR does not specify which accessibility features must be included in the self-service kiosk. However, the regulation mandates organizations must consider what accessibility features they can build into their kiosks to best meet the needs of their customers and clients. Examples of these types of considerations by organizations may include providing audio instructions in addition to visual prompts on the screen, Consider the height and stability of the kiosk. A kiosk may also be designed with specialized screens or keypads, for example, a keypad in Braille. All applicable organizations must train employees and volunteers about each regulation. All organizations must provide awareness training to all employees covering the Ontario Human Rights Code as it relates to people with disabilities. It should be noted that Ontario Human Rights Awareness training is not covered in this module. Even if you are an obligated organization, not all employees are necessarily required to be trained in the respective regulations. Training must be provided to those who participate in developing the organization's policies and all those who provide goods, services, or facilities on behalf of the organization. There are exceptions to the accessibility requirements outlined in the legislation. The Information and Communication Standard does not apply to products and product labels, information that the organization does not control directly or indirectly through a contractual relationship unless your organization is involved in the education or training as defined in this regulation. Information and communication where it is simply not possible to convert. This generally applies to circumstances where the technology to convert the information is not readily or reasonably available. A few important considerations must be accounted for in light of these exceptions, however. If your organization has been deemed to have unconvertible information or communication formats, then upon request of the customer, the vendor should provide both the reason why the information or communications are unconvertible and a summary of all unconvertible information or communications. As well, although products and labels are exempt from the accessibility requirements, it is still the responsibility of the vendor to take a person's accessibility requirements into account when communicating with the customer regarding the product. Now that we have addressed the common requirements of the Integrated Accessibility Standards Regulation, we will move to the specific requirements laid out in the Employment Standard. The purpose of the Employment Standard is to integrate accessibility into regular workplace processes and to ensure that employers provide for accessibility across all stages of the employment life cycle. The Employment Standard is the next step in the evolution of the AODA towards an accessible Ontario. Whereas the previous regulations have primarily applied to an organization's contact and service to the public, the Employment Standard addresses an employer's interaction with candidates for employment as well as existing employees. There are a number of requirements under the Employment Standard. As it was with previous standards, a good many of the requirements kick in upon the request of the prospective or existing employees. This is not to say that there are not requirements that need to be complied with before the respective deadlines. In fact, policies, processes, and communication do need to be developed and implemented. For the most part, however, the policies and communication requirements that need to be in place outline and make employees aware of the processes that are in place should a modification or accommodation be requested by an individual. As individual disabilities and corresponding needs are unique, requests made under the Employment Standard should also be dealt with on a case-by-case basis. More so than the regulations that preceded this standard, the Employment Standard is really outcome-based. Essentially, because modifications and accommodations are to be dealt with on a case-by-case basis, tailored to the need of each individual, the language in this standard allows for flexibility via consultation and cooperation between the parties so to each have a positive outcome. It should be noted that Employment Standard applies only to paid employees, not to volunteers or other unpaid employees. But it is certainly a best practice to extend the principles of the AODA to all individuals who represent or serve your organization. There are numerous requirements set out in the Employment Standard. We will now turn to addressing these requirements that are mandatory for all obligated organizations. The following requirements will be discussed in detail through to the end of this training module. The areas to be discussed are as follows: the recruitment and selection process, the interviewing and assessment components of the recruitment stage, as well as requirements concerning notification to successful applicants, providing accessible formats and communication supports in the workplace. The requirement to provide for documented individual accommodation plans as well as individual emergency response information. The requirement to develop a return to work policy and process, and requirements concerning performance management, career development and advancement, as well as redeployment. Having to cope with a disability while performing the daily duties of one's job can be a challenge for any individual. One must ponder, however, what if an individual's disability not only presented challenges to their ability to perform their duties, but also a challenge to their ability to even apply or secure the position in the first place? One of the goals of the employment standard is to remove the barriers that exist for a person with a disability in the recruitment process. The employment standard requires that all organizations must notify existing and prospective employees of the availability of accommodation in the recruitment process for persons with a disability if so requested. The notification of the availability of accommodation must be presented to the public at the time when a position is first put to the recruitment process. The legislation does not specify the location or manner in which the notification should be offered. However, it stands to reason that such notification should be offered as part of any posting, job advertisement, and job application, and ideally be placed on the website of an organization. The standard further requires that the offer for needed accommodation upon request be made throughout the recruitment and selection process. For example, should a person apply for a position and be selected for an interview, the employer should again make the availability for accommodation known to the prospective employee. As stated, the offer of accommodation for persons with a disability would ideally be made in the application, job posting, job advertisement, and on the organization's webpage. Examples of how this offer may be worded are: accommodations are available for applicants with disabilities throughout the recruitment process. If you require accommodations for interviews or other meetings, please contact the designated person. The organization is committed to providing accommodations to any individual upon request. If you require an accommodation, we will work with you to meet your needs. The next step that follows selection in most recruitment processes is the interview and assessment stage. This stage is also the next opportunity where the employer is expected to make the candidates aware of the availability of accommodation should they so request. Should the offer for an accommodation be accepted at any point during this process, the employer should work with the prospective employee to arrive at a suitable accommodation. And at that point of deciding upon and offering the successful candidate the position, the standard requires that the employer present the information and a copy of the organization's accommodation policy for their review and consideration. A few important factors that the employer must consider in this stage of the recruitment and selection process. Ensure that a safe environment is established for the applicant, free from any bias or negative stigma that may be associated with persons with a disability in the workplace. It is common practice to provide template interview and assessment tools so to ensure consistency and equity in the process, at the same time minimizing the opportunity for arbitrary judgment or bias to sneak in. Many companies, certainly as a best practice, train their recruitment and hiring personnel, whether it be in-house awareness training or formal sensitivity training. The employer should also be prepared to offer a range of accommodation options, keeping in mind that each accommodation should be evaluated on a case-by-case basis. Examples of options for accommodation in this process may include flexible timetables for interview process, the potential for a different and more suitable location or a modified room setup to better suit the individual, an adaptable interview process, or perhaps the offer of additional paperwork or paperwork in modified formats. Upon selecting the successful candidate and providing them a copy of the organization's accommodation policy, the employer should then be prepared to discuss the requirement for accommodation in their new position if needed and requested. At this point, it would be best practice to conduct a needs analysis with the employee. Taking this opportunity at the point of hire to determine the needs of the employee and the type and availability of accommodation allows both parties to be ready when it is time for the new employee to begin their position. The employment standard also requires that the employer must provide or arrange for the provision of accessible formats and communication supports for an employee upon request. The Act mandates that this accommodation may be requested by the employee for information that is being provided to all employees, as well as information that is needed or required for the employee to perform their duties. Alternatives to standard print are often referred to as accessible formats. Communication supports are methods that enable communication between people. Examples of accessible formats and communication supports may include documents in Braille or large print, recorded audio, captioning on a video, a sign language interpreter, earphones to amplify sound, or a speech-generated device. The employer and the employee should work together to find the most reasonable and suitable option for each individual. A key aspect of the employment standard is the requirement for public sector and large private employers to develop and implement individual accommodation plans for an employee with a disability who does require accommodation. A large employer is any private sector employer with 50 or more employees and does include non-for-profits. Accommodation in the workplace is not new. However, typically accommodation plans are informal, based on an understanding between employer and employee, or accommodation plans arise out of an acute incident and typically last a specific term. The employment standard requires that obligated employers provide a policy outlining the process for developing and implementing documented individual accommodation plans for employees with a disability. In effect, these individual accommodation plans become an integral part of the employment terms and expectation between the employer and employee. Employers must work with an employee with a disability to find the appropriate accommodation to meet the individual's needs. Be it each person's disability is unique, as is each workplace, so too must the individual accommodation plan be crafted or tailored to suit each circumstance on a case-by-case basis. Examples of an accommodation may range from altering the physical location or workspace of an employee to the need to provide screen reader software for a computer. Crafting the individual accommodation policy, process, and individual plans provides for the best example of how this regulation is outcome-based, allowing the employer and the employee to work together cooperatively so the process can deliver a satisfactory result. It is important to remember that all workplace processes, including the accommodation process, must be offered in a manner that is accessible to all employees. From there, the regulation mandates that the employer and employee customize the accommodation to suit the specific needs of the employee. It is precisely because every employee may require or even prefer a specific type of modification that the individual accommodation plan should outline the role of the employee in the actual process. And of course, it follows that the employee take an active role in the development of the plan. Once both parties have determined the needs of the employee relative to their disability and the duties of the position, the next step is to explore available options to address the needs in the accommodation plan. It is beneficial to both parties at this stage to explore a varied range of accommodation options. In addition, the use of outside medical experts or third-party sources to both assist in the determination of the need for accommodation as well as the potential solutions can be very helpful. The required documented process for developing individual plans must address when an employer may request an independent medical examination or when an outside expert can be used to determine if and how accommodation can be achieved. It is important for both the employer and employee to remember that it is the obligation of both parties to work together to reach a suitable solution. Not in all cases will the employee's specific preference of the type or manner of accommodation be met. In these cases, it is important for the employer to maintain an open line of communication with the employee and explain the reasons why the preferred modifications were not able to be provided. Critical to both the spirit of the AODA and the Human Rights Code is the dignity and privacy of the individual in the application of these processes. Thus, the employment standard mandates that the policy or process that governs the development of individual accommodation plans must address the steps taken to protect the confidentiality of the employee. Finally, the plan should also specify the frequency in which the details of the accommodation plan will be reviewed. Consider that an employee's needs or disability may change, as may the organization, the employee's position, or duties. Hence, it is wise that the plan not only incorporate regular periodic review, but also make allowances for review in those times of change. The requirement to provide accessible workplace emergency response information, as well as provide individualized emergency response information to employees who require accommodation in the case of an emergency, has been in effect since January 1, 2012. Existing individual emergency response plans should be incorporated into the individual accommodation plans as required by the employment standard. In cases where an employee is seeking an individual accommodation plan and does not yet have an individual emergency response plan, or in cases of existing employees that may develop or divulge a disability going forward, both the requirement for the emergency response and accommodation plan must be satisfied. All public sector and large private organizations must develop and have in place a return-to-work process for its employees. The return-to-work process applies to employees who have been absent from work due to a disability and require disability-related accommodations in order to return to work. Organizations must also document and inform employees about the availability of the process. The return-to-work process must outline the steps the employer will take to facilitate the return to work of the employee. In each case, an individualized accommodation plan must be developed in cooperation with the employee and the appropriate medical experts. As is the expectation with the policy regarding the development of individual accommodation plans that we just discussed, the same expectations are to be met as it relates to the return to work policy. Return to work programs and processes are not a new concept for most large employers. Most employers have return to work obligations under their respective workplace compensation and insurance boards, as well as under the Human Rights Code. The return to work requirements per the AODA employment standard do not supersede the authority of existing statutes. However, to many employers' benefit, most of the same tools and processes that you would use in existing return to work processes will be of value in fulfilling the requirements set out in the employment standard. The use of functional abilities or capabilities forms, as well as the use of existing reporting procedures, return to work processes, physical demands analysis, and modified job banks are all terrific resources that may already be at your disposal. Employers that use performance management processes, which includes performance evaluation processes, appraisals, tracking, etc., must take into account the accessibility needs of employees with disabilities when facilitating its performance management process. Employers are expected to be aware of the needs of an employee with a disability and review the individual accommodation plan for the employee when both setting expectations for performance and evaluating the performance of the employee through the formal performance management process. Although this regulation only applies to employers who have a formal performance engagement process in place, it is expected that the principles of the AODA and the employment standard are applied in the delivery of both the formal and informal applications of performance management. For example, pulling an employee aside to discuss concerns about their duties and the need for improvement is considered to be an aspect of performance management. Albeit the discussion surrounding the performance of the employee is not in writing and not part of a formal appraisal or evaluation, the requirement to consider the needs of the employee with a disability when having this informal discussion still exists. For those employers who do not have a formal performance management program, this standard does not impose a requirement to develop or implement such a process. However, it should be noted, other protections, such as the Human Rights Code, does mandate a requirement on the employer to consider the disability and corresponding needs of an employee in any process or decision related to an employee's performance at work. Finally, The process itself must be accessible to all individuals. Moreover, consistency in the application of the process from one employee to another is paramount. Thus, it is important that the process and environment be safe and free of all bias for employees. The evaluation of employees' performance should focus on the actual performance of the employee's duties and not on those factors that can be attributed to the disability. As well, managers or evaluators should be free of any negative stigma regarding the ability of a person with a disability to perform their duties. As it is with the evaluation of an employee's performance who has a disability, the employment standard requires that employers also must take into account the accessibility needs of employees when providing career development and advancement. It is the duty of the employer to ensure that the disability and corresponding needs of an employee do not limit access to career development and advancement opportunities within an organization. The employer should review and take into account the individual accommodation plan of an employee when considering their career development and progress. Ideally, employers and employees would work together to identify the career aspirations of the employee and lay out a path to achieve them. The employer should further work with the employee to identify and remove barriers so to achieve the goals that have been set to the mutual benefit of both the employee and the organization. And finally, in the case where an employer must redeploy staff, the employment standard requires that the employer consider the accessibility needs of employees with a disability before changes are implemented. In cases where a person with a disability is moved or transferred, it is required that the employer review and amend both the individual accommodation and emergency response plans to account for the changes. You have completed the assigned training module. You will now be required to take a quiz to affirm your completion and understanding of the content of this module. A score of 70% is required to pass the quiz. Upon completion of the quiz, you will be notified if you have passed or if you are required to take the training again. You are permitted one additional opportunity to repeat the training and pass the quiz should you fail the first time. Good luck.